Hey, have you heard it's election season here in the U.S.? Not sure if you're aware of that. Anyway, Californians, you have two pretty interesting propositions to consider on November 3rd that are related to technology, and your decisions might affect the rest of the country in a major way. For instance, there is, of course, Proposition 22, which if you've used an Uber in California at all in recent months, I'm sure you've heard about because they pop it up in the app. Uber really wants you to vote for Proposition 22. I'm going to quote here from Wikipedia. Proposition 22, titled Exempts App-Based Transportation and Delivery Companies from Providing Employee Benefits to Certain Drivers. The proposition seeks to grant app-based transportation and delivery companies a special exemption to Assembly Bill 5 by classifying their drivers as independent contractors, exempting employers from providing benefits to certain drivers. The proposition also includes additional protections for app-based workers over those for other independent contractors, but most of these protections only apply during the time the worker is, quote, engaged in fulfilling a specific request, and not while the worker is logged into the app and available to fulfill a request. Lyft, Uber, DoorDash, Instacart, and Postmates have contributed over $180 million into campaigns supporting Proposition 22, making it the most expensive ballot measure in California's history, end quote. Well, while Californians are mulling their vote on that, an appeals court in California has upheld a lower court ruling ordering Uber and Lyft to stop classifying drivers as independent contractors, which is why they're pushing Prop 22 in the first place. Quote, the ruling is unlikely to have any immediate effect on either company's services, given the ruling will be put on hold for at least 60 days. Uber and Lyft can still ask that the decision be reviewed by the California Supreme Court, which can decide whether or not to hear the case. Lyft spokesperson Julie Wood said the company was considering all of our legal options. Quote, this ruling makes it more urgent than ever for voters to stand with drivers and vote yes on Prop 22, she said in a statement referring to a November 3rd ballot measure that Lyft and Uber have been pushing for months, end quote. Now, I had heard of that one, the prop that gig companies love, but perhaps more consequential in the long term is Prop 24, which I was unaware of, and let us consider it the proposition that Google and Facebook hate. Quoting Recode. Proposition 24, also known as the California Privacy Rights and Enforcement Act of 2020, CPRA, is supposed to expand a landmark California privacy law that passed 2 years ago. There's a good chance Californians will approve this one, too. It's framed as legislation that will better protect their privacy, in particular sensitive data such as social security numbers, race, religion, and health information. And while the proposed law technically governs the use and sale of data for Californians, California has an enormous impact on the tech industry, which means CPRA will become the de facto law for all of the U.S., which should sound like a good thing for most people. Among other impacts of the proposed law, it makes a point of protecting young people by mandating triple fines for infringements against consumers under the age of 16. It will allow consumers to restrict the use of geolocation data by third parties, effectively ending practices like sending targeted ads to people who've visited a rehab center or a cancer clinic, and it will fund the creation of an agency to protect consumer privacy. Lastly, and maybe most importantly, the CPRA closes loopholes that could be exploited by big tech platforms. One aspect of this is what we're calling the switch language, which clearly aligns the obligations of third parties to serve the interests of consumers. It notes that when a consumer exercises their opt-out rights and a publisher passes their choice along to all the companies with which it works, third parties, those companies must stop reusing that consumer's data for any other purpose. This essentially forces those companies to revert to the role of a service provider. The switch language also prevents any wiggle room by not allowing contracts to override this requirement. As publishers experienced in Europe, platforms like Google and Facebook often use their unbalanced negotiating leverage to force publishers to sign over these data rights, so this section is hugely important for individual publishers that do not have the leverage to force Google or Facebook to stop mining data off their properties. Finally, CPRA clarifies that publishers are not responsible for third parties that violate the previous section, as long as they do not have actual knowledge of the violation. Taken together, these provisions reflect a thoughtful understanding of how data flows in the digital economy. They also put the onus squarely on big tech companies to tailor their data collection practices in accordance with consumer preferences, end quote. In the piece I just quoted from, Jason Kint says, CPRA isn't perfect, but it is well-intentioned. But while you may hear tech giants warning that it will hurt small publishers, he says you should probably consider the source of those warnings and the motivations behind them.